The Uvalde family's legal challenge against the gun store, the gun maker and the police, who they accuse of negligence, recklessness and violating state laws in relation to the shooting. The shooting at Robb Elementary School in Uvalde, Texas, on May 24, 2022, was one of the deadliest school shootings in U.S. history. An 18-year-old gunman armed with an AR-15 style rifle killed 19 children and 2 teachers, and wounded dozens more. The rifle was purchased from a local gun store called Oasis Outback, which allegedly failed to conduct a proper background check on the shooter. The rifle was manufactured by Daniel Defense, a Georgia-based company that allegedly marketed its products to young, violent and isolated men through video games and social media. The police were also criticized for their delayed response to the shooting, which lasted for 77 minutes while they waited outside the school. In the aftermath of the tragedy, many survivors and families of the victims filed lawsuits against the gun store, the gun maker and the police, seeking justice and accountability. They claimed that these parties were responsible for the shooting, either directly or indirectly, by enabling the shooter to obtain and use a deadly weapon, or by failing to prevent or stop the carnage. One of the lawsuits was a class action suit filed by nearly 30 survivors of the shooting, who sought $27 billion in damages from law enforcement officials. They alleged that the police miscommunicated and did not act swiftly enough to neutralize the threat, thereby violating their constitutional rights and state laws. They also accused the police of covering up their mistakes and withholding crucial information from the public. Another lawsuit was filed by 2 families of the victims, who sought $6 billion in damages from Daniel Defense and Oasis Outback. They alleged that the gun maker and the gun store violated federal and state laws by selling a weapon of war to a civilian without a proper background check. They also alleged that Daniel Defense engaged in unfair and deceptive trade practices by targeting young men with violent fantasies through its advertising campaigns. These lawsuits faced many legal obstacles, as the gun industry enjoys broad immunity from liability under a federal law known as the Protection of Lawful Commerce in Arms Act, PLCAA. This law shields gun manufacturers and sellers from lawsuits if their products are misused by criminals or others, unless they knowingly violate federal or state laws or engage in negligent or fraudulent conduct. The plaintiffs argued that their cases fell under these exceptions, and that they had enough evidence to prove their claims. However, the defendants argued that they were not liable for the shooting, and that they complied with all applicable laws and regulations. They also argued that PLCAA barred the lawsuits, and that they were protected by their constitutional rights to free speech and commerce. They moved to dismiss the lawsuits on various grounds. The lawsuits were pending in different courts at different stages of litigation. The class action suit against the police was assigned to a federal judge in San Antonio, who had not yet ruled on whether to certify the class or dismiss the case. The suit against Daniel Defense and Oasis Outback was assigned to a state judge in Uvalde County, who had denied their motion to dismiss and allowed discovery to proceed. The outcome of these lawsuits was uncertain, as they faced many legal and factual challenges. The plaintiffs hoped that their lawsuits would expose the truth behind the shooting, hold the defendants accountable for their actions or inactions, and prevent similar tragedies from happening again. The defendants hoped that their lawsuits would be dismissed or resolved in their favor, and that they would be vindicated of any wrongdoing.